A civic movement grounded in the Constitution. Patriotism explained. Not right, not left, but straight ahead.
Hey everyone, and welcome back to the Patriot Party, where truth, transparency, and constitutional principles come before politics. The Patriot Party movement is focused on re-empowering we the people, restoring accountability, and putting America first through honest conversations and real solutions. America first, not America only, because we lead by example.
Today's guest is Ilan Wurman, professor of law at the University of Minnesota, constitutional scholar, legal historian, and author of the new book, The Constitution of 1789, A New Introduction. As America approaches its 250th anniversary, conversations about the Constitution seem to be everywhere, from presidential powers and immigration to federalism, free speech, and the role of the courts. But beneath all those debates is a more fundamental question. How should Americans understand the Constitution today, and how closely does our modern systems reflect what the founders intended? Ilan has spent years studying constitutional structure, originalism, separation of powers, and the founding era. And today we're going to explore what the Constitution was designed to do, where Americans disagree about its meaning, and why it still matters 250 years later. Ilan, welcome to the Patriot Party.
Really glad to be here. Thanks for having me.
Absolutely, absolutely. So we're going to jump right in if you're ready.
Sure am.
All right.
Hit me with all your constitutional questions.
Absolutely. So as America approaches its 250th anniversary, what do you think most Americans misunderstand about the Constitution?
Well, I think most Americans have an instinct about this, but you actually laid it out nicely in your introduction that there is a huge divergence between the original meaning of the Constitution and modern practice. Actually, in many respects. And so I don't think people fully understand the degree to which our modern day practices diverge from the original meaning of the Constitution. So some examples, of course, are simply the scope of federal power vis-a-vis the states, right? So since the New Deal, the Supreme Court has interpreted the Commerce Clause, it has interpreted the taxing clause in certain ways to allow general federal regulations and spending over things that historically the states regulated. But there are other things too, like judicial power. There's a lot of dispute right now between the courts and President Trump. And the question is, are courts exercising judicial power in a way consistent with the original meaning of judicial power? Or have they taken on this more sort of legislative role? I also think more Americans are aware of this, but of course the presidency exercises way more power than historically it would have, partly because of exceedingly broad delegations of legislative power from Congress, but also because of some unilateral presidential initiative in the war-making space, for example. And so there's a lot we could talk about there, but I just think Americans don't fully appreciate this divergence. A lot of people have complaints about the modern system, and part of the reason I wrote this book, The Constitution of 1789, is not only to sort of recover this original meaning of the Constitution and the separation of powers and federalism, but because I think it would be good to recover more of it. And I think our system would be better the more aligned it was with the founders' original Constitution.
Wow, I like a lot of what you're saying. I have two comments. One, what you're saying, it kind of resonates with a graphic that we put out a while ago, and it's got the Constitution on the top, and then the bottom it's got like the capital chambers. It says this wasn't written for you. This was written this wasn't written to keep you in line. This was written to keep them in line. And I love it, and it's what you're talking about. And you touched down on something that actually was the core of, before we invented some software, but actually what you touched down on was the root of us inventing it, because I created some flagship legislation that I had an idea for but I didn't know anything about legislation, so I built the software, and then later on saw that we needed to scale it up for America. And so our flagship was for a constitutional quality control board because, it was in the news all the time. When we said overly ambiguous laws breed bureaucratic overreach and judicial activism. And these laws were, I think, intentionally vague put on the books. And that means I think they're unconstitutional to start with.
Yeah, the quality control board is amusing because the founders actually proposed in the Constitutional Convention a council of revision. They suggested the possibility that after Congress enacts legislation, some of the more adventurous proposals were also that the state legislation would be reviewed, by the way, for constitutionality or so on, and that this council of revision would be composed of judges, right, who would get to opine on, the constitutionality of congressional legislation. Of course, that wouldn't solve the problem because today judges are largely the problem, right? Judges have encouraged Congress and have supported Congress in its overreach and so on. But the council of revision was rejected because people understood that courts, in deciding real private controversies, cases and controversies between private individuals in the government, where there's a real injury, courts would necessarily have to interpret law. But I would love the idea of a quality control board of some kind. Can I be on it?
Well, you'd have to read the structure of that legislation. You have to read the structure of the legislation because there's criteria to keep it non-partisan. You have to have so much experience in law and judicial, and so many come from each state, and all that. There's a whole structure to it. Now, unless you had an amendment, there would not be any authority. It would just be about transparency. Right. So the board could review and then make it transparent. We were going to initially use it for our curriculum as a teaching tool for the Constitution before we injected the federal policy producer in it. So, but if you look at it, if you look at products, even simple products have a quality control board, and especially complex ones, and heck, does it get any more complex than designing laws?
Yeah, that's totally a fair point. I certainly think that it's true that the Constitution also belongs to the people. Right? It was adopted by the people. The people amend the Constitution. It wasn't adopted by, members of Congress, right? Members of Congress are created by the Constitution, and the Constitution gets its authority from us. So I certainly don't think the Constitution is somehow uniquely the purview of lawyers, right? Which is, some argument people make about interpretation. They're like, well, interpretation's complicated, and it's like, yeah, it can be, but at the end of the day, the Constitution was intended for the people, and the people should be able to understand it, which is why I'm also an originalist. I believe in the original meaning of the Constitution. But yeah, it's also the people can interpret it for themselves and for their own purposes, and can put forward sort of their interpretations in real ways, like in elections, right? When there are constitutional questions at issue in elections. And so I'm all for more citizen participation one way or another.
Well, in our curriculum, we teach both sides, living and the originalists, and then we also have them debate historical issues in middle school, hot topics in high school once they're trained, and we're trying to inject civil discourse back into society, and also see what resonates best with them from a young age, which side. Also, we teach media literacy in there. But what I was going to say is, me personally, I don't agree with the living side because I don't see anywhere in the Constitution where it gives the authority to subjectively interpret the Constitution. Now, I do believe in something that I call a hybrid, which is structured life. I believe at some point we need to figure out a way to call a state constitutional convention, a state called constitutional convention, and we need to define. I think it's Article 5. So then we have a mechanism, a defined mechanism to call it when it needs to be called in place, and that's the structured life I'm talking about.
Yeah. So an Article 5 convention has never been used, of course. Most amendments to the Constitution, in fact, all amendments were proposed by Congress, ratified by 2/3 of Congress, and then, or proposed or adopted by 2/3 of Congress, and then ratified by 3/4 of the states. But the states, or the people in the states through this convention process, can also propose amendments to the Constitution for subsequent ratification. And that has never been used. Why? It's kind of interesting. Because Constitution making is hard. Right, and that's also a reason to really respect and venerate the work that the founders did themselves. Everyone, Jefferson said that every 19 years we should have this new constitutional convention because the earth belongs to the living. And Madison's response was, well, constitution making is hard, and it's a confluence of a unique sort of opportunity that the founders found themselves in, where they put aside jealousies and animosities, and they really rose to the occasion in a very unique way. And can you just imagine the people having constitutional conventions every 19 years? I mean, it's a little scary of a thought. But having said that, Matt, I absolutely agree that the people need to amend the Constitution once in a while, right? I mean, it used to be amended more frequently, and it's been 50 plus years. Now, there was an amendment in 1990. In the 1990s, okay, the 27th Amendment, but it was actually proposed in 1791. Okay, so excluding that for purposes of discussion, the people really haven't amended the Constitution since the 1970s. And the longer we go on without a convention or an amendment, the further away the Constitution feels from us, right? It doesn't feel like our Constitution. And so I've proposed amendments that, progressives, conservatives, yeah. Go ahead.
Well, I mean, I put out a graphic with my hybrid, and on the graphic I say if it doesn't grow, it dies. It's got to grow, and it doesn't need to be an easy mechanism, but there needs to be a defined mechanism, not some ambiguous language that's going to leave it to the Supreme Court, and then we end up with the judicial branch making laws. I really feel there needs to be a defined mechanism in there, and we could lay that out if there was ever one called.
Yeah, and one proposal, that I have advocated, which I actually do talk about in the Constitution of 1789 in the book. There was this case called Ines v. Chadha, where we, Matt, you and I already just talked about this, that Congress, since the New Deal, has delegated increasingly broad powers to the executive. And in these statutes, part of the deal was that Congress would retain what was called the legislative veto. So we delegate all this power to the president and to the agencies, but you, the president, the agency head, must submit what you do to Congress before it goes into effect, and Congress gets the choice to veto it on the back end, right? The problem is that the Constitution, as currently contemplated, really doesn't have a place for a legislative veto, right? If Congress wants to pass a law, it has to, use bicameralism. Both houses of Congress have to enact something, and presentment to the president. The president has to sign it. A legislative veto doesn't go through the president, so it's not lawmaking, but if it's executive power, Congress doesn't have the executive power. Anyway, so the Supreme Court rightly held in 1983 that Congress could not retain a legislative veto for itself. But it strikes me as like a good idea, right? As a good way for Congress to retain its legislative power in this world of increasingly broad delegations of power to agencies and to the president. And so I proposed a legislative veto amendment, something that would give Congress the power to put vetoes in its legislation. And this amendment had the support of progressive scholars, conservative scholars, and libertarian scholars in the project in which I proposed this. But look, I don't know, Matt, you're closer to the people probably than I am on this, but do you think people would crawl over glass to vote for a structural legislative veto amendment to the Constitution? It's not that sexy, is it?
I don't know. I guess it depends if it was paired with anything. I guess it depends on how it was framed. It could definitely be framed with what the good it could do. You just have to simplify. One of the things we're doing right now with complex legislation for municipalities, we're scanning complex legislation and we're telling them what works and what hadn't worked, so they can make better decisions. So you can make that sound really, or you can make it sound really complicated. I guess it depends on how you package it and flip it, and present it to people.
Maybe you and I can team up and we can get a plan to submit this to all the state legislatures, right, to propose it, or so at least we can get some interest in ratifying. Because I think Congress would be happy to do this, right? Because the amendment would simply give Congress more power, right? Because it would allow it more flexibility, delegating things to the executive, but also retaining sort of this back end check. And I feel like the state legislatures could get behind it, right? It's just.
I think that you and I need to do some more talking. We probably bore the listeners, but you and I need to do some talking off air. I think something that you'd find, and I'm going to go to the next question, that you'd find super interesting if you haven't seen it, is on our proof of concept page. One of the prototypes was we tried to create term limits without having to get a constitutional amendment. And we believe we've created one that will survive Supreme Court. I don't know. You might want to check it out, see how we've done it. I believe we've created it. It's not really term limits. It's a civic reintegration, and it doesn't really disenfranchise voters because you can still run. But since the states control the ballots, they have to write your name in on the ballot after 2 terms. So it lets the people know if you're writing their name in, hey, they're kind of trying to be a lifetime politician. And the way we have it is you have to cycle back out for, I think, 1 term, and then you can rerun again. Because that way you go back and live with the people. Because, we've said before, when Washington went to D.C., they made it better, and then they went back to the farm. Nobody wants to go back to the farm anymore. They want to stay in D.C. because they're treated like rock stars.
Yeah, but Matt, if we did that, then I wouldn't be able to track Nancy Pelosi's trades, and then my stock portfolio would be much more impoverished. For that reason.
Well, she would have to make up for it on the years that she was there, so I'm sure you could track them when she was in office.
Yeah, no, that's exactly
She would probably stay in office anyway, no matter what you did. So let me get to this next one. So your book is titled The Constitution of 1789. Why is it important to understand the Constitution as it was originally written before debating how it should be applied today?
Well, that's a great question. And I think the answer is, the question really is, where does law come from? Okay? I think law I don't want to oversimplify it for your audience, but, law can come from custom, for example. But I think in our system, people understand that the law comes from an authoritative lawgiver. And who is the authoritative lawgiver when it comes to the Constitution, when it comes to distributing and assigning powers to the people who will govern us? And the lawgiver is the people themselves. And so the law comes from an instrument in which the people express their will and their intentions. And that means you have to interpret the Constitution that they wrote with its sort of original meaning. And so I think that's important to recover in my book for a number of reasons, but the primary reason is because that is the legal constitutional regime that we the people approved. To the extent that we live in a modern day system that diverges from that, that system was not created by we the people. It might have been created by our representatives in Congress, whom we do elect over time. It might have been created by judges who are appointed by people whom we elect. So that's true. The people are involved sort of in that process. But at the end of the day, the Constitution is intended to bind the people who govern us. I think you made that point, right, at the beginning of this conversation. And so it can't be that the people who govern us, including the courts, right, can decide on the scope of their own powers, right? And so that's why it's important to go back to the original substance, to the original content, to the original text, to the original meaning of the Constitution. And the second thing I'll say is because I actually think, and I mentioned this point already, it's normatively desirable. But part of the reason I wrote this book is to create admiration for the constitutional rules, the constitutional system, the constitutional regime that the founders set up, because it's remarkable, right? It was remarkably successful for its time, and certainly as it's been amended, right, for our time, in doing the things that a free constitution or a constitution for a free people has to do. It has to create the conditions for human flourishing and human happiness. And that requires preserving a large measure of natural liberty. But it also requires assigning powers to the government so that they can regulate people's enjoyment and exercise of liberty, so we can live in a political community together. And it's just amazing. People today, who want to update the Constitution and say the founders were outdated. It's like, were they outdated? Like, are we still not interested in things like liberty and political community and human happiness? I mean, they were after all the same things we were after. Human nature hasn't changed, right? And I think they were remarkably successful at coming up with a solution for this problem, right, of how you balance freedom on the one hand and coercion and liberty and order and restraint on the other so that we can live together in a community in close proximity with one another, right? I just think they did a wonderful job. And so it is both because I think that's where law comes from and because I quite admire the actual product that they wrote, which is why I think we should start with the text of the Constitution of 1789, and it's why I wrote this book.
Absolutely. You kind of have to know where you came from to know where you're going, don't you? I mean, either you don't really have a good destination if you didn't come from anywhere. You have to know where you came from, what your foundations are.
There is I've joked about this before. I'm not want to quote socialist historians often, but there's one socialist historian, E.P. Thompson, who had a wonderful line in one of his famous books in which he says, we must be wary of the enormous condescension of posterity. We can look back 230 years from now and we say, oh, George Washington had slaves, you know, how backward. Thomas Jefferson had slaves. Again, that's enormous condescension of posterity, right? We celebrate them not because they had slaves, which everybody had slaves in human history up until their point. We celebrate them for their accomplishments, right? Which accomplishment, and our society today wouldn't exist without their accomplishments. The Reconstruction Amendments, the 14th, 15th Amendments, 13th Amendment, the Civil War was built on their accomplishments. To the extent you approve of the Progressive Era amendments, right? Not sure I love the federal income tax, but there are other amendments, right, that, granting women the right to vote. None of that would be possible without the edifice, without the work that came before from the framers. So I absolutely agree and continue in my admiration of the framers, despite any shortcomings that they may have had, which they all had, and we have today.
Yeah.
Right?
And I partially blame media for statements like that, because they don't give the full narrative. And, when we launch Truth Matter News next year, the streaming channel, that's going to combat that. A constitutional news channel through a constitutional lens, nonpartisan, what we know, what we don't know, what's assumed, everything fact-based, independent, verified, no rumor mills. We're going to combat that because the thing is you got people saying that, but they don't realize, or you got people saying, well, he didn't give his slaves away until he died, but they don't realize, well, in most states that was against the law. And they don't realize, well, it made people only worth 3/5. Yeah, because it was actually a power play to get rid of slavery so that the southern states didn't have as much voting power. It was they couldn't get rid of it all at once. But they don't give the full narrative. They just demonize things just for clicks.
You and your audience will love chapter 14 of my book, where I talk all about the founders and slavery in this issue, because we talk about the Dred Scott case and how the Supreme Court got the Constitution and the founders terribly wrong. And Matt, what you've just said strikes me as like a much more sophisticated account than most academics give these days, right? Because the answer is it was complicated, right? And the thing about the 3/5 clause, so just zooming out for a second, was the Constitution pro-slavery or anti-slavery? The answer was, in my view, generally anti-slavery, but it's complicated, right? So again, what was the lay of the land before the Constitution, right? Before the Constitution, the Confederation could not prohibit the international slave trade. The British Empire refused to prohibit the international slave trade. For the first time, Congress was empowered to prohibit the international slave trade. For the first time, Congress was empowered to prohibit slavery in the territories. So they stopped slavery from coming in from across the seas, and they could stop slavery from expanding westward through the territories. The Constitution preserved abolition in the northern states through its federalist structure. You were getting to this, but slavery had been universal in human history. Every state of the Union had slavery as of the day America declared independence. And then half the states abolished slavery or set a timetable for abolition after the Declaration of Independence, right, when the Revolutionary War began and so on. Now, look, the 3/5 clause, as you said, is actually the trickiest clause, in my view, one of the trickiest clauses. It was intended as a compromise. Like, from the Southern perspective, which I think you were suggesting this or intimating this, the South wanted a 5/5 clause because they just got extra political power in Congress, right? And we said, no, you'll only get 3/5 bump in Congress and representation, and we will be allowed to tax them. Well, the problem is a direct tax on slaves was really rarely implemented. So it turns out, and then the cotton gin was invented, which economically, benefited slavery, which they did not know that at the time, right, that it would be invented. And so the 3/5 clause turned out to actually be a boost in the political power of the South through about the 1830s or 1840s. Which is why the South had such a stranglehold on national power. And finally, when the North outstripped the South in population, in education, in industry, because the South was being held back because of its slave economy, right? people say, oh, we owe our economy to slavery. So no, the economies that had slavery were held back because of it, right? And anyway, finally, the North outstripped the South in its population, in its political power, and for the first time, an anti-slavery candidate won election, and what does the South do? Oh, we secede now that we finally lost. And this is what Lincoln meant in the Gettysburg Address, right? Can a free government endure, right? If the first time you lose a national election, you say, okay, I'm out because now I lost. That's not how democracy works, right? You have to stick to the deal even when you lose. Okay, so I'm going a bit far afield now, but the point is the slavery and the Constitution was very complicated. Generally, it was anti-slavery. The 3/5 clause was, I think, intended to be anti-slavery, but after the Cotton Gin, it had a pro-slavery effect for 3 or 4 decades, which we shouldn't ignore. But again, it was not intended. It was not intended that way. One last point about were the founders themselves pro-slavery, anti-slavery. And you can go through all of these statements from the founders where they said, look, it's evil, we need to abolish slavery, we don't have an immediate solution to it. But what's so fascinating, and I try to emphasize in the book, it's the Southerners themselves in the 1840s, 50s, and 60s who admitted that the founders were anti-slavery, including the Southern founders were anti-slavery. And it's the Southerners in the 1830s, 40s, 50s, and 60s that were like, we are more enlightened than the founders. We now understand that the white race is superior and that the black race is inferior and they deserve to be slaves, right? That was a Southern innovation of the 1830s, 40s, and 50s. So, you have Senator Robert Hunter on the floor of the United States Senate in 1860, a senator from Virginia on the eve of the Civil War, saying, we in Virginia have shifted our ground. We no longer believe what Thomas Jefferson and George Washington and James Madison and James Monroe believed. All the leading men of Virginia believed that slavery was an evil and should be eliminated. We now believe, we've shifted our ground. We now believe that slavery is a positive good, right? A benefit to the master, a benefit to the black man as well as the white man. And so it's just, I think to say that the founders in the Constitution were pro-slavery is just such like a historical simplification that, quite frankly, I find it embarrassing when academics make points like that.
So I want to put a little perspective. We don't normally get to talk about this kind of stuff, and I want to put a little perspective on it. Maybe you may have something to add or push back. I don't know. But from my research, we always talk about slavery, and you were talking about how every state had it. But if you look back in history, well, one, slavery's always been prevalent. Not that it's right, but two, you'd be hard-pressed to find any race of humans that haven't been enslaved at some point in history.
I think that's right.
And I want, what you say?
Yeah, I think that's right. And so let me emphasize 2 things. One is, again, the period between 1776 and 1789 was the greatest emancipation in world history up until that point, perhaps until 1833, when the British Empire abolished slavery in the rest of the empire, okay? But that was 50 years later, 40 years later, right? The Americans did it first because of this revolutionary fervor. The other thing, Matt, about your point, is that a lot of people will say, well, racial slavery was uniquely evil and was uniquely American. And I do think racial slavery is more evil than merely, slavery by conquest. But to say racial slavery was somehow unique to America is also profoundly ignorant, right? There was the white slave trade where the Barbary pirates, right, the Islamic states in North Africa enslaved something like 1.25 million okay, white Europeans in a period of a couple hundred years from 1500 to 1800, okay? As of the day the international slave trade was abolished in 1808 by Congress, there was only about 1.5 million or so slaves in the United States, and a lot of that was natural increase. So the white slave trade from the Islamic states in North Africa was much more well, I don't want to say it was much more barbarous, but it was, the same order of magnitude, if not worse, right? Of course, there was also the Arab slave trade of Africans themselves, which was objectively, I think, more barbarous than the European slave trade in this regard. And then, of course, there was in Africa, they were enslaving other ethnic minorities and so on. So yeah, racial slavery is more evil, I think, than like the slavery of the Roman Empire period, where it's just like you were conquered and we took you as slaves, right? Josephus was a slave in Rome, but of course he was free to write his history and so on. But to say again that somehow America is uniquely evil, when of course America started started humanity on this abolitionist path because they wrote for the first time in a foundational national document that all men are created equal. Right? I mean, it's just
You took the words off my paper. I was getting ready to say that next. I was like, to your point of what you were saying. Literally, I have it written down right here. You took it right off my paper. Yes, it was the first document, right, in history to ever say that. Right.
That's right. That's right. And it had been, of course, asserted, since the English Civil War. By people in England in the 1600s, fighting royal prerogative and monarchism and so on. But it was the first time that it was established as a foundational principle of a national polity. And that's huge. That's huge. And so it's untrue to say that America was somehow uniquely evil with respect to slavery. And in fact, that really perverts the truth in another way, because America was actually uniquely good in its contributions to mankind and to the abolition of slavery.
So if you think about it, actually probably America was the catalyst for the world kind of pushing away from slaves.
Yeah, that wouldn't surprise me. That's a great question. I haven't studied why, as of 1833, the British Empire finally abolished slavery. But I'm sure they were embarrassed, when they compared themselves to America. Now, there was still slavery in the South, right, in America. Again, this idea that all men are created equal contributed to the French revolutionary ideas, contributed to the ideas in England throughout the 1800s as they became more liberalized. And so the world owes so much to this American moment of 1776 and of 1789, our Constitution. And so it's
which is, again, from not giving the full narrative. You zoom in on one thing and you beat it down instead of zooming out and saying, hey, this is great because we were the catalyst for the world. I mean, it should be inspirational. As long as you learn, from the mistakes and you don't repeat them. I mean, that's what you're supposed to do. You evolve. You learn. I mean, we're human. We make mistakes. I know it was a big mistake, but it was a historical mistake made for thousands of years, and we stopped it. So
right.
I think
there
it's good. So, go ahead.
Yeah, I was going to say, I know you're nonpartisan, and this organization is nonpartisan. I will say that, there is something unique, I feel, to the left, to progressives, which is this narrative that America has always had this problem and almost always will have this problem, right? Look at the achievements in abolition from 1776 to 1789. Look at the achievements of the Civil War and Reconstruction, where 600,000 white people died, right, for the freedom of the former slaves. Look at the Civil Rights Acts in the 1960s. It goes from America had this original unique racial slavery sin to it's still systemically racist today and still suffering from this. It's always the same story. It's never a story of redemption.
But it's the media that keeps pumping it in, this division. And I feel, and I don't know if it's by structure, if it's not, but I feel there's control in division and in chaos. And if you keep injecting chaos and keep everybody split instead of coming together, then you have more control, and the status quo is fine.
Yeah, there's just something so weird about it. Look at the wondrous achievement of abolition from 1776 to 1789. Look at the wondrous achievement of the Civil War and Reconstruction. Look at the wondrous achievement of the Civil Rights era. But it's never that. It's never that. It's always the opposite. Look how terribly evil and systemically racist we still are. I think that's dangerous. I think that's a dangerous ideology because it's false and it's insidious.
It is, but it's being amplified. If you look at it even deeper, if you look at what I think the root is, it's a systemic problem, and I mean that from what you're paid for. If you look at social media or Google, you're paid for emotional clickbait. That's what you get. The more viral, they don't pay for substance. They pay for emotional clickbait. So, literally, I don't post anything partisan. I continue to say we are a civic movement to re-empower the people. But for 6 months, I have had to explain. I don't anymore, but for 6 months, I had to keep explaining, I'm not a Nazi. Everybody kept calling me a Nazi because it was just look at it, what's the name, click through, that's what you are. And I think we have to start, whatever you monetize, whatever you reward, society will do. So if we monetize substance over emotional clickbait and virality, then that's what the creators will produce, and that's what people will reintroduce critical thinking back into society at a systemic level.
Speaking of which, monetizing substance, I don't monetize it yet, but I hope I can mention on your podcast that I have a podcast, which I hope people will listen to. I'm here not only to plug my book, The Constitution of 1789.
Absolutely.
Recently out, but we have a podcast precisely for this reason. It's called Rationally Based. And you know why? Well, it's a play on the rational basis test, which is this legal test. But it's also because we want to explore the rational thinking and reasoning behind some positions that people consider, based and edgy and so on. Like, we're unafraid of investigating and interrogating what people are thinking about things and the truth of the matter. So it's two law professors who are very conservative, right of center, me and one other, and we have a non-lawyer who's absolutely wonderful, young and radical, and says what all the young people are thinking, and then it's our job to sort of discuss it. So it's rationally based. And I hope we give that kind of content that you're suggesting, or that more people should be giving. So I hope your listeners will check us out. Rationally Based.
Well, I wish you'd have told me about it. I just had on we had on a guest a few shows ago. He was a lawyer, a law professor actually, had his own podcast. Bob Martin. He was like big time in the '80s with the Cocaine Cowboys under Janet Reno, and then he defended the cartels. Kind of a big time lawyer, had his own podcast. If you told me that, I'd have had it in the daggone description and the introduction. But yeah, absolutely, mention it. We want to send people there. We're not stingy. We want to send people places to get information, to get good information.
I appreciate it. You too, Matt. You will love that podcast. I think it'll be right up your alley. Two law professors who love America and care about America and the Constitution, and discussing sort of conservative intellectual ideas from a law professor perspective. So I hope.
Absolutely. When I send y'all a link to this one, you'll have to send me a link to yours so I can check it out.
Please.
Okay. So, looking at today's political environment, where do you think the greatest misunderstandings exist regarding the separation of powers?
Oh boy. So the separation of powers, traditionally, in a sense, my whole book could be considered to be about the separation of powers, right? But traditionally, it's understood to be Congress's powers, its legislative powers, versus the president's executive powers, versus the court's sort of judicial power. And one thing, I think you're going to agree with this. The conventional view, which is correct in part, is that the separation of powers exists to prevent tyranny. James Madison and Montesquieu and Bolingbroke and others describe tyranny as, the combination of power, legislative, executive, and judicial, in unified hands, right? So you want to separate these powers to prevent tyranny. But it's also the case that each institution of the national government was structured and created in a certain way so that it would exercise its power well. So the Congress, it's representative. You have constituencies from across the country where representatives have to debate each other. You have two branches. You have bicameralism, so you slow down the deliberative process. When you're making legislation, rules with legal effect and force of law, and altering the legal state of the world, you want to deliberate. You want to take opinions from across the country, and you want to slow down deliberation and so on. And so Congress is structured in a way to conduce to proper legislating. The president has the application of the public force. The president executes the law. The president has to stop criminals and fugitives, and has to prevent invasions, repel invasions, and prosecute wars. You can't have a Congress deliberating on execution of law and repelling invasions and which hill will the military take. So the president was made unitary because a single president at the head of the executive branch would have more energy, would be able to exercise power with some secrecy and dispatch, right, and quickly, energetically. And then the courts are structured in a certain way as well. The courts have lifetime tenure and salary protections, so they can adjudicate cases under existing law, not make new law, right? They apply existing law to resolve private disputes involving the life, liberty, and property of the subject, free of political influence, free of political control. So I think it's important to understand that each institution of government was structured in a way to conduce to its functioning, its exercising its function well. And when Congress starts delegating too much power to the executive, for example, then that undermines the reason why we have a bicameralist representative body making laws in the first place. When Congress takes away from the president unitary control of the executive branch, that takes away from the purpose of having sort of a unitary president at the head. And of course, when judges start lawmaking from the bench, they're not, that's doubly bad because they should be applying law, not making law, but because they're politically insulated, which is, they're politically insulated because they're supposed to exercise judgment under existing law. They're not supposed to make new law. And yet you have judges today going totally wild, making up law all the time and restraining, especially President Trump, but it happens across the board with both parties and so on. And so I think once you have an appreciation that the institutions of government were structured in a certain way so that they could exercise their functions well, you start to see all of these deviations in a new light. It's not just to prevent tyranny. It's because judges shouldn't be lawmaking. Deliberative representatives should be lawmaking, right? The president should be able to execute rigorously, right? And judges should exercise judgment without political control and influence, right? So all of these problems that we have today, delegation, unitary control, judicial lawmaking, is put in this interesting perspective once you understand that the separation of powers wasn't just about preventing tyranny, but also about each institution doing its function well.
I love you're talking about separation of powers, checks and balances, all that. We actually have created this whole movement based on that. So the American Institute for Civic Leadership, that's the education part. That's a 501c3. I'm just a founding partner. I'm not even on the board of that because Civic Truth Media Group, which is the for-profit, which is ours, it makes the education tools and all that stuff, which they license for fair market value. Then the Patriot Party is the conversation part, and then next year we're doing a 501c4 for constitutional activism called Patriot Advocacy, and they all work in tandem with truth, transparency, and the Constitution. That's what they're working towards. It's meant to be a nonviolent generational realignment.
I love it. And then your mug says dad, which is important, right? Because family. And then you got the eagle and the I love it. Your organization just seems really great. And I'm so glad to be having this conversation with you.
Man, I appreciate that. Let me get to another question because I know we're going to be crushed for time and I want to get these last two in. So many Americans feel that government institutions have become increasingly disconnected from the people. Does the Constitution provide mechanisms to address that concern?
Well, the most important thing, of course, is elections, right? And I do want to, so let me take this opportunity. This is not in my book, because my book is really about the written Constitution. I do think there are unwritten, small c constitutional principles, not necessarily judicially enforceable, but that should be adhered to by the people, right, and their representatives, that I think are important for a functioning constitutional democracy, right? Just to give you an example, you might think academic freedom is like an important sort of constitutional principle. It's not in the Constitution anywhere. I don't think academic freedom is compelled by the First Amendment in any way, but that could be an example of sort of this small c constitutional principle that we generally believe should be followed. But I think a far more fundamental one is free, fair, and open elections. And this is really important because elections were the way that people would keep the representatives accountable. And look, putting aside voter fraud in elections has always existed. And actually, if you listen to the Rationally Based podcast, we did a really fun episode about election integrity a few weeks ago. Did you know that the National Election Day is on a single day in November? Because there used to be an election month where the states could have their presidential elections anytime as long as the electors met by a certain day in December, right? But the problem is, apparently they were like busing, on horses and carriages, right? People would vote in one state and then they would be transported to another state whose election was held on a different day. So fraud has always existed. Whether fraud has existed in sufficient quantities, right, to alter elections, certainly locally that's been the case, that's been true occasionally throughout American history. The point, though, is people should have confidence in elections and that a lot of election laws exist because there have been opportunities for fraud historically, because fraud is hard to detect. And so you have election laws to prevent the opportunity for fraud. And what happened in 2020, by the way? I'm not saying the election was stolen. I am not saying that. What I am saying is there were election laws that were changed at the last minute, And election laws are there, and they exist for the purpose of preventing opportunities for fraud. And so it strikes me that we need to have an electoral system that inspires confidence in the people, that deters opportunity for fraud, because fraud's hard to detect and so on. And that is a small c constitutional requirement of a representative electoral democracy, right? And I think, certainly the narrative on the left is like, oh, there's nothing to see here, which is like totally false. The narrative on the right is, oh, dead people are voting and they're literally making up votes, which has happened sometimes historically, unclear, exactly in what amounts. But I think the narrative is different. The narrative should be elections are so fundamental to the belief of the integrity of the system. Elections are the way that, after the Constitution is put in place, the people's representatives, judges, the president will be kept accountable. And people have to believe in our elections. And there are just such simple things that can be done to instill faith in our elections that for whatever reason, one side of the political aisle refuses to do, which is you can come up with reasons and so on. But that's one response I would say to your question.
Okay, well, I am going to have to respectfully push back a little bit, because what we say on this show all the time, you can't fix a broken system in the broken system. A mechanic can't fix a car while he's driving the car. He's got to get out of the car and work on the car. So, and most of the time when the politicians get out, they're burned out anyway. They don't want anything to do. They want to write a book and retire. So that's why we say that the answer is not in politics. The answer is in we the people. We the people can fix the system, but in reformed citizenry is the ultimate checks and balances.
Yeah, no, I absolutely agree with that. I think there are things, of course, Congress and incumbents sometimes benefit from the existing system. And I do think that there should be more ways for the people to circumvent Congress, right, to propose amendments to the Constitution, for example, which is really difficult. But yes, maybe a simpler answer, Matt, to your question would have just been an informed citizenry. I tell you what, if everyone just buys my book, that'll make a more informed citizenry.
There we go. Well, too, what we're trying to do, if light is the best disinfectant, then transparency is our best tool to clean things up. So this movement, if I had to describe it, is transparency. We are literally using new technology to take complex stuff that's available to us and simplify it to shine light on the government, to shine light on corporations. And so normal citizens can make more informed decisions. We're trying to level the playing field from the guy who's got a great idea but doesn't have 15 years worth of legal training. We want to bring everybody in and make people start to take a minute to look at narratives and critically think again. We've lost that with the 2-second swipe. We used to have 30 seconds for advertising time 20 years ago. We got 2 seconds now.
I love that. And if there's any way I can help you reach younger people, high school students, college students with constitutional knowledge from like a, constitutional law professor with some, influence, happy to help with that project.
Absolutely. Really right now, we just want people awareness. We did, back after I got home from my honeymoon, our Louisiana legislators wouldn't answer me. So I hopped a flight, documented the whole thing, had 1 million people following on social media, viewing it, and went right in their offices and went and met with everybody, all our Louisiana legislators, and stayed the week. Never been in D.C. Went in through like the TSA, taking your clothes off, with I call this my D.C. bag. I bought it just for D.C. We went down there and went in the office. They were like, you can't do that. I said, yeah, we can. They're public officials. Watch me.
I love that. I love that.
So let me ask you one more question, because I know we got to wrap it up. As we approach America's 250th birthday, what lessons from the Constitution are most important for the next generation to understand?
Oh my goodness. I hope, that my book is action-packed with sort of lessons, right? For each aspect of the Constitution, right? So let me just do a quick tour and maybe tease out some lessons that people could use, right? The book starts with, where did written constitutions come from, and what is the nature of the American Republic? And, people still talk about secession, and so stop talking about secession. Secession is unconstitutional. Secession could be revolutionary, right? You could revolt against the existing system, but the Constitution was adopted by the people in the states, not by the states, and the people are entitled to their benefits. So stop talking about that. If you want to talk about revolutionary acts, we can talk about that. But to say a revolutionary act like secession is constitutional, as Andrew Jackson said, is conflating ideas. It's conflating terms. Those are not sort of the same thing. Congress, moving to legislative power, is a branch of enumerated powers. It is assigned specific powers, and everything else is left to the states. There is a movement among modern academics to say Congress is not limited to what it can legislate. It's not limited to its enumerated powers. This is false, and I hope to show that that is false. In my book, let me say something about executive power. There's a debate about the scope of the executive's power and the president's power. And what I try to show in my book is that the framers in the Constitutional Convention specifically created a unitary executive, a single executive, after they carefully circumscribed the president's powers. They decided a single executive could be safely entrusted with these carefully defined powers, carrying into effect the national laws, appointing officers to assist in that task, controlling the military, being the commander-in-chief. But that's really it. Congress gets a lot of the historically royal powers, which I think is sort of an important lesson. Again, restoring Congress's role. The judiciary, we talked a little bit about this, but historically, judicial power was just the power to decide particular cases and controversies involving individual parties. And the courts get things wrong all the time. But they don't bind the president or the executive with respect to non-parties, which is a huge issue today. What happens when the courts get things wrong, as they did in Dred Scott? Abraham Lincoln said, I respect the judgment in Dred Scott v. Sanford. It doesn't mean I have to follow the Supreme Court's erroneous interpretation of the law in other cases. So I think that's really important. Let me say two final things on the scope of national power, and we started with this, Matt. The national government has totally exceeded its original grant of powers by interpreting the Commerce Clause to basically give Congress the power to regulate all economic activity of national life. Historically, agriculture, production, wages, hours, minimum wage, all of that was stuff for the states. And God forbid, let the states experiment a little bit, with different policies. So the Congress has greatly exceeded its power. And then finally, in the last chapter, the most controversial thing I say in my book, Matt, which relates a little bit to a project of yours on health savings accounts, I think, is that I think most national welfare programs are probably unconstitutional under the original meaning of the first clause in Article 1, Section 8, which is just a power to raise taxes. It's not a power to just spend money beyond the enumeration of powers. But I think letting people keep their money and traveling, and they could carry it from job to job and residence to residence, I think would probably be constitutional. But those are just some lessons I hope your listeners will take and my readers will take from my really action-packed, I hope, book.
Absolutely, I love it. Absolutely. This has been a pleasure. If you don't mind hanging around, I'm gonna wrap it up, and then maybe we'll have a minute or two to talk off air.
Sure.
Good deal. Ilan, thank you for joining us and sharing your perspective. Whether people agree with every interpretation or not, I think understanding the Constitution and engaging seriously with our founding principles is one of the most important conversations Americans can have. I appreciate you taking the time to be here. And until next time, remember, truth isn't partisan, it's patriotic.